सुप्रीम कोर्ट ने उत्तर प्रदेश सरकार को फटकार लगाते हुए कहा कि वह अदालत के आदेश की अवहेलना करते हुए आचार संहिता का हवाला देते हुए छूट याचिकाओं पर निर्णय ले रही है, जबकि अदालत ने आदेश दिया था कि छूट पर निर्णय लेने में आचार संहिता आड़े नहीं आएगी। अदालत ने पिछले सप्ताह उत्तर प्रदेश के कारागार विभाग के प्रमुख सचिव को अदालती आदेशों का पालन न करने पर आज वीडियो कॉन्फ्रेंसिंग के जरिए पेश होने का निर्देश दिया था। जस्टिस अभय ओका ने कहा कि आप हर मामले में हमारे न्यायालय के आदेशों की अवहेलना कैसे कर रहे हैं। हर मामले में जब हम आपको समय से पहले रिहाई के मामले पर विचार करने का निर्देश देते हैं तो आप उसका पालन नहीं करते। इस पर यूपी सरकार के वकील ने कहा कि राजेश कुमार सिंह से जुड़ी सभी मामलों की फाइलें सक्षम अधिकारी के पास हैं। वह बाहर थीं, आज आने की संभावना है और इस पर कार्रवाई की जाएगी। हमने 5 जुलाई को संबंधित मंत्री को फाइल भेजी और वहां से 11 जुलाई को सीएम और 6 अगस्त को राज्यपाल को भेजी गई। जज जस्टिस ओका ने कहा कि देरी के लिए कैदी को मुआवजा कौन देगा। इस पर यूपी सरकार के वकील ने कहा कि हमें 16 अप्रैल को प्रस्ताव मिला और इसी बीच आचार संहिता लागू हो गई। तब जज जस्टिस ओका ने कहा कि हमने कहा था कि यह आड़े नहीं आएगा। इस पर यूपी सरकार के वकील ने कहा कि सीएम सचिवालय को फाइल नहीं मिली। इस मामले में आदेश देते हुए सुप्रीम कोर्ट ने कहा कि यूपी सरकार के वकील के पास इतनी देरी के लिए कोई स्पष्टीकरण नहीं है। उन्होंने कहा कि इस न्यायालय द्वारा पारित आदेश के बावजूद की आचार संहिता छूट याचिका पर निर्णय लेने के रास्ते में नहीं आएगी। सीएम के सचिव को भेजी गई फाइल स्वीकार नहीं की गई। आचार संहिता खत्म होने के बाद ही फाइल सीएम सचिवालय को भेजी गई। हम पीएस को निर्देश देते हैं कि वे हलफनामा दाखिल करके उन अधिकारियों के नाम बताएं जिन्होंने फाइलें लेने से इनकार कर दिया। कोर्ट ने अपने आदेश में कहा कि वह यह भी बताएंगे कि क्या उन्होंने संबंधित अधिकारियों के समक्ष यह प्रस्तुत करने का कोई प्रयास किया कि सरकार न्यायालय के आदेशों से बंधी हुई है। अवमानना नोटिस जारी करने से पहले हम श्री राकेश कुमार को निर्देश देते हैं कि वो हलफनामा दाखिल करें जिसमें उन्होंने मौखिक रूप से जो कुछ कहा है उसे शामिल करें।
They are not part of the actual order that is recorded by the learned judge.
Lord,
these are part of the proceedings, as you have mentioned in the video. So, in course of the proceedings, sometimes things are said and they are depicted and they are portrayed. But we are really concerned with what eventually is written down in the order of the learned judge. Now, obviously, as you have rightly pointed out, these orders could have been avoided, that kind of sentences, that kind of tone, tenor, even from there, as you said, the words spoken speak louder than words written. Well, perhaps you are right in that, but eventually, when we sit in the Supreme Court, we have to go by what is written down in the order. After all, the proceedings in the court are proceedings where we normally say that free flow of exchange between the bar and the bench.
No, I bow down, my lord. It's your lordship's wisdom. I am not, my lord, for or against anything, but the video which is, my lord, viewed by everyone is post this judgment where the learned judge says that you do not know. I have even nullified I have declared even Supreme Court judgment, that is this order, to be non-est, and one division bench order to be non-est, and all judge. Well, Lord,
now that video which has been recorded is while hearing which proceeding actually?
Hearing, my lord, proceedings where the division, as I pointed out, the division bench said that you have transferred the land to the government, which we stayed.
This was in response to the order of the division bench directing the adjournment of the proceedings.
Yes, my lord. That's what, my lord, the learned judge said.
Declared by the division bench.
It was
yes. Yes. So, there are 2 division bench judgments, my lord, the learned judge is referring to, that I have nullified them, and even Supreme Court I have said that it's a nullity. It's non-est order. And say that all our, he is talking about the peer brother judges, that they need to be sent for judicial training, etc.
While presiding over the court, he is the master of that particular court.
Correct.
And he adjudicates the matter before him or her. And eventually, if you really look at it in a larger perspective, even the Supreme Court is not supreme, the High Court is not supreme, the Munsif is also not supreme. The supremacy is actually of the Constitution.
Absolutely.
We are all below the Constitution, and our task is to interpret the Constitution as we understand. And that is what the task.
And
of the court is.
144, that everyone should
And
work in aid of the Supreme Court of
Supreme Court orders. Right, you are right there. 144 is a very glaring instance.
I only two reflections to share with the court.
Yes, Mr. Attorney.
One that while the court exercises the power under Article 129, it is not necessarily bound by the Contempt of Courts Act and all those finer nuances of scandalizing the court, etc. It is a feel of the court in the context of a particular instance as to what may constitute interference with the administration of justice and lowers the integrity of the institution, both of the High Court as well as the Supreme Court. Here I find the learned judge, in fact, has brought down the integrity of the institution of the High Court as well. Therefore, that's how one has to look at it. In whichever way, without further damaging the fabric of the institution of the High Court in the hierarchy, I think whichever way the court would like to intervene, I think the court may like to follow that.
It's entirely my Lord's wisdom and discretion. But now we are in the era of live streaming. And this is how it is recorded, my Lord, and the video is doing rounds. That's my concern.
Serial number 301, we find that there are two lawyers who have connected from Chandigarh, perhaps, Mr.
Lord, I am the counsel in the SLP, in fact, in which the contempt proceedings were stayed. So I thought it's my duty to be here, my lord, as an officer of the court. I was the counsel in the SLP, my lord, for the petitioner.
Anybody else who's online? He's the only person. This court has taken up these proceedings. The court has taken up these proceedings suo motu, the context of an order dated 17 July 2024, passed by Justice Rajbish Therawat, Judge of the High Court of Punjab and Haryana, while entertaining a contempt proceeding titled as Naughty Ram versus Devendra Singh IAS in another, COCP-87-2022, bracket O and M. Stop. The underlying facts which gave rise to the contempt proceedings are not a matter which needs to engage the attention of this court. Stop. However, while dealing with the contempt proceeding, Justice Therawat has made observations in regard to the Supreme Court of India, which are a matter of grave concern. Stop. Since the order forms a part of the public record of the High Court, it is unnecessary for this court to extract those observations, particularly given the course of action which this court proposes to adopt. The principles governing the committee between the High Courts and the Supreme Court as the apex judicial institution in the country have been dealt with in numerous decisions of this court. We may only reiterate the principles which have been laid down in the decision in Tirupati Balaji Developers versus
These are all the decisions, if your lordship would like to, I have compiled.
2004, 5 SCC, page 1. Stop. Judicial discipline, particularly in the judicial discipline, the context of the hierarchical nature of the judicial system is intended to preserve the dignity of all institutions, both the district of all institutions, whether the district, High Court, or at the level of the Supreme Court. Stop. We are of the view that the observations which were made in the order of the single judge dated 17 July 2024 were totally unnecessary for the ultimate order which was passed. Some gratuitous observations in regard to previous orders passed by the Supreme Court, or for that matter, in the course of this same proceedings, are absolutely unwarranted. Full stop. Compliance with orders passed by the Supreme Court is not a matter of choice, but a matter of a bounden constitutional obligation, bearing in mind the structure of the Indian legal system and the authority of the Supreme Court, which heads the process of judicial adjudication in the country. Stop. In passing its orders, including orders of the nature that gave rise to the observations of the single judge, this court discharges its plain duty. Full stop. Parties may be aggrieved by an order. Full stop. Judges are, however, never aggrieved by an order which is passed by a higher constitutional or appellate forum. Full stop. The observations. Full stop. The learned Attorney General for India and the learned Solicitor General have, while dilating on the background of the case which led to the passing of the order dated 17 July 2024, have submitted that the order of the single judge has affected the dignity not only of this court but of the High Court as well.
और आप हमसे जुड़े रहने के लिए सब्सक्राइब करें YouTube पर, फॉलो करें Twitter पर और लाइक करें Facebook पर। और ज्यादा जानकारी के लिए आपको टाइप करना होगा सिर्फ न्यूज़ नशा।